I'm not going to talk about anything that I haven't said in court or in the papers. These are all great questions, but I'm just not going to get into it. So
can you speak about your concerns about the leak in the video? You have spoken about that before.
I did it in the court papers, and I'm just going to stick to the court papers.
From a new trial date to allegations of government misconduct to issues surrounding an accuser to a third attempt to get out of pretrial detention, we are breaking down some major recent updates in Sean Diddy Combs' case. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Look, I get it. It can be tough staying up to date on everything that is happening in the Sean Diddy Combs criminal case. There is a lot that has been happening. So what we want to do for you is give you some of the top recent updates on the case so that you're caught up to speed. Now, before I even get into the updates, I have to set the stage. The 54-year-old music mogul, still locked up, still locked away in the Metropolitan Detention Center out in Brooklyn as he awaits trial on federal sex crimes charges, racketeering conspiracy, sex trafficking, transportation to engage in prostitution. Essentially, prosecutors from the Southern District of New York allege that Combs used his business empire and resources and associates to lead a criminal enterprise that was engaged in illegal activity like arson, bribery, kidnapping, even the assault and sex trafficking of women, and that this was going on for years. And more specifically, they allege that he brought in male sex workers for these events called freak-offs, these elaborate sexual performances that he forced, threatened, or coerced people to be a part of, even drugging people, filming these sessions. That's what the allegations are. And it's a complicated case, which brings me to the first update. When on earth is this trial actually going to happen? Well, at a status hearing last week, prosecutors, the defense attorneys, and the new judge overseeing this case, the Honorable Arun Subramanian, agreed to a trial date of May 5th, 2025. Now, obviously, that can change. For a variety of reasons, but it seems to me that the defense has been pushing for this early trial date. I mean, we were suggesting this trial wouldn't happen until the end of 2025, maybe even 2026. But the reason that it seems to me that Combs is wanting an early trial date is because he's locked up. He doesn't want to be there anymore. And even though he is appealing his bail, or his denial of bail, I should say, to a new court, and we're going to get into that in a minute, he and his team may be thinking, let's get him to trial as soon as possible with the hope that he's acquitted and he can go home and put it all behind him. We don't want him languishing behind bars for another year or 2 years as he waits to go to trial. But there are a few things with that. You know what could change the trial date? You know what could delay it? If Combs is hit with new charges, if there is a superseding indictment, that's when prosecutors go back to the grand jury with new evidence in an effort to indict Combs on additional charges. They may also upgrade charges. They may even replace a charge. And that means more discovery, more evidence, more material that needs to be shared, more motions. The timeline would shift. You won't see a May 5th, 2025 date if he's ultimately hit with more charges. Very, very, very unlikely. And in a major update during that hearing, we found out that's not so far-fetched. Assistant U.S. Attorney Emily Johnson told the court that the investigation is very much ongoing and that there is a possibility of a superseding indictment. And why would that happen? Well, it could be that through their investigation, analyzing the digital and physical evidence they collected, speaking with more witnesses, including maybe new people who may have come forward, prosecutors may believe they have probable cause that Combs committed more crimes. And by the way, it's interesting during this hearing that prosecutors said their case as it currently stands will take them about 3 weeks, and the defense said their case will take them 1 week. First of all, if there's additional charges, that will change. But the current case taking 3 weeks, the defense saying they'll have 1 week. What that tells me is that the defense is going to mostly focus upon cross-examination of the government's witnesses, instead of really calling witnesses of their own. I mean, maybe the defense will call these alleged male sex workers to say that all of these freak-offs were consensual, that no one was pressured, no one was threatened, no one was forced to do anything. And overall, that idea of this being all consensual seems to be what the defense's main theme will be. particularly if you believe that victim 1 in the indictment, who is not named, but a lot of us believe is Cassandra Ventura, Combs' ex-girlfriend, who accused him in a separate lawsuit of physically, sexually, and psychologically abusing her. In this criminal indictment, prosecutors say he sex trafficked victim 1 through force, fraud, or coercion, meaning forced her to perform commercial sex acts. Now, it would seem to me that if she were the government's star witness, Combs' defense attorneys would spend a lot of time cross-examining her, suggesting that everything was consensual, that she agreed to everything. And by the way, going back to the timeline here, yes, the government says that their case would take 3 weeks to prosecute, but does that account for the time that the defense would cross-examine their witnesses? How long would the cross-examination of a Cassandra Ventura take? Would it take several hours? Would it take a day? By the way, his defense attorney has also suggested that Combs may take the stand. Would that be the majority of the week as well? What would the cross-examination of Sean Combs take? So even though we're saying it could be 4 weeks, I would imagine it would take a little bit longer. By the way, going back to Cassandra Ventura, his defense team most certainly will cross-examine her, try to get her to say everything was consensual. That yes, she was his girlfriend. Of course Combs flew her around. Of course he had sexual activity with her, but he didn't pay her. He didn't promise her anything to engage in sex acts, that she was a willing participant in these essentially orgies. So the estimate from both sides of how long their case will be is very interesting, to say the least. But of course, again, that could change if there are new charges. Now, there was another major update that happened, and it was also addressed in this hearing. The defense's argument that the government engaged in misconduct. In a filing from last week, Combs' defense counsel blames the government, more specifically the Department of Homeland Security, of leaking information and making inappropriate comments to the media, and the defense is now asking for an evidentiary hearing to get to the bottom of all this. More specifically, they allege that the Department of Homeland Security agents leaked the infamous 2016 videotape of Combs purportedly beating Cassandra Ventura in a hotel hallway, which was published by CNN in May of 2024. And remember, that was after the raids on his houses by Homeland Security before his arrest. They say they leaked it. So Combs' defense counsel in this filing wrote, quote, "The available evidence makes a prima facie showing that the government, primarily through DHS, has engaged in a 7-month campaign with 3 objects. 1, preventing Mr. Combs from getting fair consideration by the grand jury. 2, preventing him from getting a fair trial. And 3, strategically leaking confidential grand jury material and information, including the 2016 Intercontinental videotape, in order to prejudice the public and potential jurors against Mr. Combs." Pretty startling allegation there, but they continue. "The government's scheme to undermine Mr. Combs' rights to a fair proceeding has several methods and means. First, there has been a steady stream of false and prejudicial statements made by DHS agents to various press outlets over the last 7 months. For example, Combs' lawyers allege on March 27, 2024, 2 days after the searches of Mr. Combs' residences, an agent specifically identified as working for DHS made public statements to, among other media, the New York Post, that he believes there is a disturbing history of sex trafficking. We are responding to concrete, detailed, explicit allegations. This is not random. We didn't choose his name out of a hat. We had allegations that we're following up on." Second, Combs' lawyers write, the agents encouraged in a particularly brutal and public search of Mr. Combs' homes, during which they handcuffed Mr. Combs' innocent sons and then marched them before a news helicopter in the press. This was an apparent effort to convey that they had overwhelming evidence against Mr. Combs, justifying the public and brutal treatment of even his children, who were handcuffed and manhandled by federal agents armed with assault rifles. Third, government employees have repeatedly leaked grand jury information and materials to the press to raise public hostility against Mr. Combs in advance of trial. And when it came to the source behind the leak of the 2016 tape, Combs' lawyers wrote, "An unrelated third party is not a likely source. If a person not in law enforcement were to leak the videotape to a news source, that person likely would have sold the tape rather than simply give it to CNN." So prosecutors, they responded to this by providing the court with a copy of an email that they had sent to Combs' lawyers on October 9th. And it reads, "To be clear, to our understanding, DHS did not have possession of the videotape prior to CNN's publication of it. Only the government has authority to obtain grand jury material, and the video broadcast by CNN was not obtained through grand jury process. So very interesting there. Now, at the hearing, Prosecutor Johnson said that all the defense is trying to do is exclude a damning piece of evidence, seemingly referring to the 2016 videotape. And that is something Combs' lawyers have asked for, because if this evidence was improperly leaked by the government, then there is an argument it should be suppressed, that it shouldn't come into Combs' trial. That would be a big win for him. Well, Judge Subramanian reserved ruling on whether to order an evidentiary hearing to sort all of this out. He said he wants to wait to review each side's arguments, which are due by November 7th, and then he'll see if a hearing is warranted. Now, what the judge did do during this hearing, and this is going to have an impact, is impose a gag order. Now, this was something that the defense had asked the court to do as well. They wanted to stop the government from disclosing material to the media. The federal prosecutors at the hearing were like, okay, we'll agree to that, but the defense, they need to agree to the same, because they say the defense hasn't been so innocent in all this. They called out Combs' attorney Mark Agnifilo for doing an interview with TMZ right after Combs was arrested in September, where he called the criminal case, quote, a takedown of a successful black man. Prosecutor Johnson said this sounded like he was accusing the feds of engaging in a racist prosecution. Johnson said statements of this sort seriously risk a fair trial in this case, so Judge Subramanian instructed Combs' team to propose an order that would govern public statements by both sides. And when reporters flocked around Agnifilo after this hearing, he definitely wasn't as forthcoming as he'd been in the past.
I'm not going to talk about anything that I haven't said in court or in the papers. These are all great questions, but I'm just not going to get into it. So
can you speak about your concerns about the leak and the video? You have spoken about that before.
I did it in the court papers, and I'm just going to stick to the court papers. As you guys all know, let me just finish. As you all know, I made a request today for what we were calling a gag order, and I'm not going to walk out of court and do anything other than live up to that.
Talk about his demeanor in jail and what it's been like.
So here's what I'm going to do. I'm not going to answer any more questions. I want to help you guys out, but I'm not going to do it. I'm going to go back and speak to my colleagues, and then I'm going to be
just
done.
tell us about the
thanks.
MDC and what it's like.
Yeah. Thanks, guys.
Can we see him being transferred anytime soon? Can we see him being moved anytime soon, or?
Sir, which way are you headed to go? Which way would you like to go? Okay, yeah, let's go this way.
Now, there was something else that happened during the course of this hearing that we have to address. The amount of discovery in this case. The prosecution indicated the vast amount of material for their forensic teams to extract and review. And I'll give you an example. Prosecutor Johnson said this week that 96 devices were seized in those March raids on Combs' properties. Phones, laptops, hard drives. 51 of the devices were from the LA raid, 36 were from the Miami raid, and 9 were taken from Sean Combs himself. In fact, 8 of the devices in that Miami raid contain over 90 terabytes of information. Think about that, 90 terabytes. What do you have, like 2 terabytes on your iCloud storage? Think about how much that is. And she indicated that extracting that data has been a process. The reporting indicates, though, that the prosecutors have been in constant contact with Combs' attorneys regarding this discovery. In fact, we learned that the government made its first production of material over to the defense on October 7th, so this is ongoing. And what the defense received was search warrants, Combs' iCloud reports, Combs' iPhone activity, so that's going to be a lot to go through as well. And the prosecution expects to turn everything over to the defense by December 31st. Again, given the sheer amount of data, it is surprising that we expect the defense to be able to go through all of this and be able to mount a defense by May 5th. Very, very ambitious, in my opinion. So to be clear, though, we don't know what all of this evidence contains, but at the very least, as based on reporting and prior comments from the prosecutors, they appear to be in possession of videotapes of perhaps the freak-offs, perhaps other alleged criminal activity, but there's probably text messages and photos and a lot to go through as well. Also, while discovery is due by December 31st, I will also let you know that the motions in this case are due by February 17th, 2025, oppositions by March, replies by March 10th, and then trial on May 5th. Again, ambitious. Assuming there are no snags, assuming there are no further issues, we'll see. Now, there is another update in this case that we have to talk about that wasn't addressed at that hearing. It's something that is happening in a different court. You see, Combs has appealed his denial of bail to a higher court, the Second Circuit Court of Appeals. And remember, 2 different judges already denied him pretrial release. They said given the gravity of the allegations, the weight of the evidence, the potential danger he is to society, the risk of flight, and moreover, allegations that he had been improperly contacting witnesses and alleged victims, Combs should not be let out pending trial. Well, Combs' attorney, Alexandra Shapiro, filed a motion for pretrial release last week with the Second Circuit Court of Appeals, and Shapiro opened the motion by writing, quote, "This case does involve extreme and unusual circumstances, but none that typically foreclose bail or warrant forcing Sean Combs to defend himself from a prison cell. What is extreme and unusual about this case is that Mr. Combs was detained immediately after he was charged, even though he has been in the spotlight his entire life, with many of his purported antics and episodes being widely reported in the press and known to law enforcement authorities. Indeed, hardly a risk of flight. He is a 54-year-old father of 7, a U.S. citizen, an extraordinarily successful artist, businessman, and philanthropist, and one of the most recognizable people on earth. The sensationalism surrounding his arrest has distorted the bail analysis. Mr. Combs was not released pending trial, even though he offered to comply with restrictive conditions that would have prevented any conceivable risk of flight or danger. And remember, Combs had offered a $50 million bail package, putting up his Miami home and his mother's home as collateral, promised to stay in constant contact with authorities, only speak to certain people, would have visitor logs handed over to the court, only certain people would come to the house. He even proposed having a third-party security team monitor his house when he would be under home confinement. And in this motion, Combs denies the government accusations of obstruction. His attorneys concede, yes, he spoke with people about the civil lawsuits he was facing, but says he wasn't aware that the Southern District of New York was investigating him. And once he realized he was being investigated, the appeal motion says he made sure not to continue contact with those people. The motion reads, although the government vaguely described contact with 2 grand jury witnesses, it proffered no evidence of any threats or intimidation. The government could only state there were 14 total contacts between Mr. Combs and 1 witness and another witness who was contacted multiple times. Defense counsel explained those contacts involved no obstruction or witness tampering. For example, 1 witness contacted Mr. Combs, not the other way around. She reached out to Mr. Combs and told him, "I'm a grand jury witness." After Mr. Combs informed defense counsel, he was instructed not to contact the witness anymore and didn't. So Shapiro argues the prosecution didn't meet its burden to hold Combs until trial. They've raised a number of very compelling and interesting arguments. Not clear when the court will hear arguments on this or what a decision will be or when a decision will be handed down, but very, very interesting arguments put forward by Sean Combs' defense counsel. Now, I will say this. If Combs were to make bail, would he still want a May 2025 trial date? Would he not want to see this trial much later on? After all, he faces a significant risk and possibility of conviction and being sentenced to serious prison time, perhaps a minimum of 15 to 20 years behind bars if he's convicted. Why wouldn't he want to be on house arrest for as long as possible and try to delay this trial as much as he can? Now, he could feel confident in his case. Maybe he wants to hold the prosecution's feet to the fire. Maybe he wants to get this trial over with as soon as possible. But all I'll say is, if he's granted bail and he is released pending trial, do not be surprised if he then tries to delay the trial date. I just put in that warning. Now, I will say this. Mark Agnifilo did indicate that Combs is not trying to move from the MDC while he awaits the issue on bail. There was reporting that he was requesting to be transferred to a facility in New Jersey, but Agnifilo seemed to say that the MDC had been responsive, so it appears he is going to stay there as he fights this bail issue. And when we talk about major updates in the Sean Combs case, as we talk about potential new charges, I would be remiss if I didn't mention another major update in the Combs case. A Texas attorney named Tony Busby announced that his law firm plans to pursue legal action against the music mogul. And this would be on behalf of more than 100 victims. More than 24 of those future plaintiffs say they were just kids when Combs allegedly assaulted them, including a 9-year-old. And attorney Busby says it's not just Combs caught up in the crosshairs.
The wall of silence has now been broken, and victims are coming forward. Our team has had at this point more than 3,285 individuals contact us with people claiming to have been victimized by Sean Combs. We now represent 120 individuals who intend to bring civil claims in civil court against Sean Diddy Combs, as well as claims against many other individuals and entities that we will name as defendants as we file these individual cases. I expect that through this process, many powerful people will be exposed. Many dirty secrets will be revealed. We know what we are potentially up against. As is always the case in situations like this when a celebrity is involved, people can be downright mean and nasty. You'd be shocked at the length fans will go, no matter the evidence, to the contrary, to defend celebrities they love. I mean, there's a reason for this word fans. They're fanatics. I've personally already been threatened multiple times on social media. And when I agreed to pursue this, I expected as much. This isn't my first rodeo. But victims who step forward to have their voices heard should not be subjected to that kind of conduct. They should not be targeted.
And by the way, according to TMZ, Busby has already sent out demand letters to a bunch of celebrities in order to get them to settle before he files lawsuits against them. Those, he says, who were complicit or participated in this alleged abuse by Sean Combs. And he also claims that some high-profile people have already settled. Now, he says that he's going to first file lawsuits against corporate entities who facilitated the abuse and then file the lawsuits against the celebrities. So it's going to be a very interesting series of weeks ahead. But here's the thing, and I've said this from the beginning. Busby is the latest in a long line of accusations from other people who have sued Combs that claim he abused minors. And yet, nothing in his criminal indictment, nothing in Sean Combs' criminal indictment is about minors yet. Given this announcement, could we expect a potential superseding indictment to include such allegations regarding minors? Not only would that delay a trial date, but it would make Combs' defense much more complicated. There is no consent defense when it comes to minors. And legal experts I've spoken to have indicated, by the way, that Combs may move to stay, meaning pause, all of these potentially 120 lawsuits until the conclusion of the criminal case, which is something we have seen before. And finally, one more update for you on the civil front that may affect the criminal case. And this is with respect to Adria English's lawsuit against Sean Combs. This is the person who claims that she was sexually assaulted and trafficked by Sean Combs at his infamous white parties. Well, her lawyers have withdrew from the case. And here's the thing. Her attorneys were Ariel Mitchell-Kidd and Stephen A. Metcalf. Ariel Mitchell-Kidd, as you might remember, has been making the news recently, most famously telling News Nation that a sex tape of Sean Combs and an unnamed high-profile celebrity is currently being shopped around. Now, what happened here? Well, English's former attorneys cited a breakdown in the attorney-client relationship and irreconcilable differences. In fact, Mitchell-Kidd told the New York Times on October 3rd that, quote, she never lost faith in English's actual case, just in her. Mitchell-Kidd said, her case is great. My issue was with her undermining my work and going behind my back, doing things incongruent to advancing her case. But English seems to be celebrating that these attorneys are no longer on her case. In a statement over the weekend, English wrote, I am happy with the decision to withdraw, and this has made it easier for her to secure new professional non-clout-chasing counsel. Wow. Now, she has indicated that she has until November 11th to find new lawyers, or she will represent herself in this case. Now, we don't know if Adria English is a cooperating witness for the government's criminal case against Sean Combs or not, but when you see these headlines and you see accusations against attorneys who may be representing potential witnesses for the government, it does make you wonder about the credibility of these witnesses, no? What will cross-examination be like if perhaps Adria English is a cooperating witness and is going to testify against Sean Combs? Will she continue to be a witness? Interesting to think about. How strong is the prosecution's case? This is what I think about. People from all over the country have been reaching out to Texas attorney Tony Busby to put their claims against the rapper on the record. Now, at the beginning of this month, Busby announced that his firm had gotten thousands of phone calls with stories of sexual assault and mistreatment, and that he vetted more than 100 cases that they believed they could take to civil court. Now, during his news conference, Busby emphasized that Combs' alleged victim pool was vast, covering different ages and genders and races and locations.
You should know, in this group, it is evenly divided between males and females. There are 60 males and 60 females who have joined us to pursue these claims as plaintiffs. In this group, 62% identify as African American, 30% are white, and the remainder are Hispanic or Asian. The victims are from more than 25 states. The majority are from California, New York, Georgia, and Florida. Our youngest victim at the time of the occurrence was 9 years old. We have an individual who was 14 years old. We have one who was 15. 25 of the 120 individuals who are plaintiffs in these cases were minors at the time of the acts complained of. Most of these events and incidents occurred at parties, typically after parties, or album release parties, New Year's Eve parties, 4th of July parties, something they called a puppy party, all-white party, although several of these events occurred at auditions. Many times, especially young people wanting to break into the industry, were coerced into this type of conduct in the promise of being made a star, or in the promise of having Sean Combs listen to their tape or even let them read for Sean Combs.
Now, Sean Combs is, of course, a Grammy-winning music producer, rapper, behind the record label Bad Boy Entertainment, the Sean John clothing label. He's been a staple in entertainment and music for years. But now, anytime you mention his name, really what it comes back to is that he is an indicted defendant in New York. He's an accused sexual predator. He's been charged with racketeering conspiracy, sex trafficking, transportation to engage in prostitution. Prosecutors allege that Combs used his power, his money, his influence to force employees, commercial sex workers, even unsuspecting women to facilitate and or participate in the now infamous freak-offs, described as hours-long sex performances that were usually recorded without the people's consent or knowledge and propelled by illegal drug use. But here's the thing, prosecutors aren't the only ones making allegations against Combs, because we know that Combs was already facing a whole slew of civil lawsuits prior to this week, with a civil action that was filed by his ex-girlfriend Cassandra Ventura in November of 2023. We believe that that was the lawsuit that really kicked everything into high gear, all the lawsuits, ultimately the criminal charges. And remember, Ventura claimed that during her on-again, off-again relationship with Combs, he forced her to partake in these freak-offs to the point that everybody would need an IV drip to recover. Now, during his news conference, going back to attorney Tony Busby, he said to the public and the media, you should expect the first of more than 100 new civil lawsuits to be filed against Combs in the next 30 days. But what happened? The first 6 came much sooner than that. Now, as a note, Combs has adamantly denied any and all allegations, old and new. In a statement, Combs' legal team said that this is a clear attempt to get publicity. The attorney said they and Combs have full confidence in the facts, their legal defenses, and the integrity of the judicial process. In court, the truth will prevail that Mr. Combs has never sexually assaulted anyone, adult or minor, man or woman. However, in his own statement Monday, Tony Busby said, quote, the Busby Law Firm, along with co-counsel AVA Law Group and New York local counsel Curis Law, is filing 6 cases this week alleging aggravated sexual assault, sexual abuse, and sexual exploitation against Sean Diddy Combs and those entities with whom he has been affiliated, to include in one case Macy's department store and in another Marriott hotels. The cases are being brought for conduct that occurred over a span beginning in 1995 through 2021. All of the events occurred in New York and are being filed pursuant to the Victims of Gender-Motivated Violence Protection Act, which we'll talk about in a minute. 4 of the alleged victims in these cases are male, 2 are female. One was 16 at the time of the alleged occurrences. We will let the allegations in the filed complaints speak for themselves, and we'll work to see that justice is done. We expect to be filing many more cases over the next several weeks, naming Mr. Combs and others as defendants as we continue to gather evidence and prepare the filings. Okay, so with that, we're going to be focusing on one lawsuit. We're going to be focusing on the allegations being made by the now grown man who says that he was 16 when Combs assaulted him. He is identified only as John Doe in this lawsuit. And while there have been accusations in prior civil lawsuits that Combs engaged in inappropriate or even illegal behavior with minors, to be very clear about something, his federal criminal charges do not relate to children in any way. There is, of course, the chance that there will be a superseding indictment meaning that prosecutors go back to the grand jury with evidence of additional crimes that may relate to minors, but we're not at that point. He's not being charged with respect to minors currently. Having said that, now let's go back to this lawsuit. Let's break it down. So the lawsuit that was filed in New York federal court begins. This case seeks compensatory and punitive damages for the sexual assault of a minor. Let me stop right there. So compensatory damages are, yes, to compensate a plaintiff for what happened to them, to make them whole again. Punitive damages are a way to punish the defendant for really egregious conduct. So we start there. The assault, which was part of a practice that defendant Sean Combs had of grooming or attempting to groom minors, occurred at what was termed a white party at Combs' residence in New York. The conduct described herein is shockingly typical of defendant Sean Combs. Combs was aided in his abhorrent conduct over the years by many individuals and entities. Sean Combs for many years believed he was above the law. He is not. First glance, practice, typical, conduct over the years, these terms, I imagine, will not only be a theme in this lawsuit, but the other lawsuits that are filed by Tony Busby. But it is also a common theme in the prosecutor's indictment, too, that there were these alleged repeated patterns of illegal conduct by Sean Combs. Now, some of the accusations that are made against Combs in this lawsuit, they really echo some of the overt acts that prosecutors have pointed to in their effort to make the case that Combs was running a criminal enterprise. So in this lawsuit, it reads, Combs is one of the wealthiest musical artists in the world. Behind the facade of being a 3-time Grammy Award winner, discovering and developing multiple famous musical artists, ranking on Forbes' list of the highest paid entertainers in the world, there existed something sinister, a dark underbelly of crime, sex trafficking, forced labor, kidnapping, bribery, and prostitution. This is almost verbatim in a way from the criminal indictment. It goes on to say that Combs is a menace to society, women, and children. While his wealth has kept him above consequence for years, Combs now faces the awesome power of the American judicial system and ultimately a jury of his peers who will be asked to punish him for the deplorable conduct described herein. Now, Combs isn't the only one that John Doe is suing in this lawsuit. Now, the lawsuit also names Daddy's House Recordings, this is a recording studio in New York, Combs Enterprises, Bad Boy Entertainment, Bad Boy Productions, this is amongst others. And the reason is because, as they say, quote, Combs and his agents, employees, and contractors through these Combs businesses would tell victims, this is what it takes to be famous. What are you willing to do to become a star? And perform this sexual act or else, to coerce the victim into performing a non-consensual sex act for the gratification of Combs and his cohorts. Each of the Combs corporations aided and abetted Combs in committing the unlawful sexual violence against plaintiff described herein, are alter egos for Combs, completely dominated by him and used for his personal interest and to engage in wrongdoing which harm plaintiff and others, and or serve or have served as vehicles for Combs to move, dispose of, and or insulate his assets, including connection with his criminal activities, and to avoid compensating the victims of his many crimes, including plaintiffs. So big theme there that Combs had control over these entities. Sometimes we see these cases where corporations and business entities are trying to be held liable for the conduct of an employee or an associate. Sometimes the defense will be that this employee is not really an employee, is not acting within the scope of their employment, that there is a separation between the company and the defendant. Here, if you're saying he's in control of all these entities and is using these resources and assets for his benefit to perpetrate a crime, that argument becomes a lot more difficult. But going back to the lawsuit then goes on to describe what happened to John Doe, or what John Doe says happened to him. Mr. Combs' legendary white parties in the Hamptons were well known by many, including John Doe, the kind where countless celebrities would attend. In 1998, when John Doe was only 16 years old, he was recruited out of New York City and indeed, while residing in New York City, received an invitation to one of Combs' parties through a mutual connection. As John Doe made his way through the crowd toward the restroom, he unexpectedly bumped into Combs. Shocked, John Doe found himself face to face with Combs, a titan in the music industry, standing right in front of him in his own party. Doe took a picture with Combs at the 1998 party. Now, here's the thing. That picture is actually included in the lawsuit. John Doe, whose face is blurred out, is standing next to a smiling Sean Combs outside, clear as daylight. The lawsuit goes on to say that Combs took an interest in John Doe and wanted to talk to him. They walked to a more private area near the portable restrooms brought in for the party. There, John Doe told Combs he was a big fan of Combs and shared his dreams of becoming a star. Combs smiled, telling him he had potential and the look. When John Doe admitted his voice was not great, Combs assured him that did not matter. Combs made clear that the only thing that mattered was having the right look for the industry, and with it, Combs could transform Doe or anybody into a star. Combs abruptly told John Doe that he needed to drop his pants. John Doe, caught completely off guard, confusingly asked Combs to repeat himself. Combs made himself clear. He instructed John Doe to drop his pants and expose his penis so that Combs could inspect it, explaining it was a rite of passage and the route to becoming a star, and also as a way to prove himself. "Don't you want to break into the business?" Combs allegedly said. Doe immediately felt uncomfortable, froze, and did not know what to do. Combs remained calm and stood in front of him and stretched out his hand in a cupped position. Out of fear, anxiety, and the imbalanced power dynamic between himself and Combs, John Doe then dropped his pants and exposed his penis as Combs previously instructed. Now that point's really important because to anybody that would say this is consensual, and by the way, when you're talking with a minor, there is no such thing as consent, but generally speaking, that power dynamic becomes a key in sexual assault cases as well as sex trafficking cases. So that power dynamic, that fear, becomes a really, really big, important factor. But what does the lawsuit claim? The lawsuit claims that Combs groped this teenager, that he sexually assaulted him, apparently, by the way, without any concern that someone might walk nearby or see them. And by the way, when you think about that, if this were to go to trial, Combs could say, would he really do something like this in the open where anyone could observe this allegedly criminal behavior? The other way of looking at this, and I don't know if this would make its way into this kind of trial, remember what we all saw. Sean Combs in 2016 purportedly beating Cassandra Ventura in a hotel hallway while wearing a towel. If we want to talk about what's blatant and out in the open, is that not a pretty clear example of what he potentially is capable of or allegedly capable of? And by the way, he admitted that in an Instagram post 2 days after that video was released by CNN, basically said it was him. So if he would beat somebody in a kind of a public area like that, is it beyond the realm of possibility that he could do something like this? Again, very unrelated incidents, but something that I thought about as I was reading this lawsuit. Now, John Doe says that after several minutes, Combs walked away from this assault as if nothing had happened. The complaint reads, as a result of Combs' sexual assault onto John Doe while he was a minor, John Doe experienced damages, including pain and suffering, mental anguish, physical impairment, and emotional torment. The interaction continues to humiliate and cause shame on John Doe. Because of Combs' power and notoriety, plaintiff was afraid to report what had happened. John Doe became yet another sexual assault victim of Combs through the same pattern and abuse of influence Combs exercised over others previously. Now that's important because it goes to the argument of why now? If this goes to trial and this accuser testifies, you know he's going to be grilled about why he is coming out now to file this lawsuit. The allegation would be put forward by the defense, he's only doing this to jump on the bandwagon, that this isn't true, that he's just looking for a payday. Everybody else sued Sean Combs, why not do the same? But this assertion in this complaint suggests he was in fear. And that is a common theme from many accusers. We have seen it in a lot of different sexual assault cases, whether civil cases, criminal cases, that people do not come forward for a variety of reasons, and that can't necessarily be used against them. Sure, Sean Combs would have the opportunity to cross-examine this witness, goes to his credibility, totally fair game, but the other way of looking at it, we have a much different and deeper understanding of sexual assault today than maybe we did 10, 15 years ago. And remember here, the argument is, and we've seen this reflected in other lawsuits, that it took Cassandra Ventura and others to file their lawsuits, and especially now for Combs to be locked away in pretrial detention, for these people to feel safe to come forward with their own allegations. So we will see how that shakes up. Now, the lawsuit names one cause of action: violation of New York City's Victims of Gender-Motivated Violence Protection Act. This is important. We've talked about the GMVA before. It has been cited as a cause of action in numerous prior lawsuits against Sean Combs. So John Doe's legal team argued why the GMVA would apply to this case. They write, the requirement that the crime of violence be committed because of gender or on the basis of gender and due at least in part to be an animus based on the victim's gender is satisfied because defendant Combs forced plaintiff to engage in a sexual interaction without consent. John Doe could not effectively consent because of his age. The non-consensual sexual touching of a minor herein presented a serious risk of physical injury and, in fact, caused such injury. And by the way, there is now a look-back window to sue for these kinds of claims that would otherwise be time-barred. People can sue under this law until February 28th, 2025. That is why we are seeing a lot of these lawsuits. And by the way, another significant difference between this law and, let's say, the Adult Survivors Act in New York, which also created a look-back window to sue, but for specifically sexual assault claims, this Protection Act allows plaintiffs to recover not only damages, but also attorney's fees and costs, which can be quite significant. But what about the businesses associated with Combs? The lawsuit says, quote, the Combs business enabled Combs to commit the crime of violence motivated by gender by failing to, among other things, protect plaintiff from a known danger and or have sufficient policies and procedures in place to prevent sexual assault and or train their employees on identifying and preventing sexual assault. Given long-standing pattern and practice of committing sexual violence against minors who were boys, including on premises owned and or operated by defendants, the Combs corporations had and or should have had knowledge that Combs was a danger to plaintiff and did nothing to stop Combs. The Combs corporations further enabled Combs to commit the crime of violence motivated by gender by actively placing, maintaining, and or employing Combs in a position of power and authority, despite the fact that they knew and or should have known that Combs had a widespread and well-known practice of committing sexual assault and gender-motivated violence, including on premises owned and or operated by defendants. And as I mentioned before, we've seen this in other lawsuits. The defense would be that Combs wasn't acting within the scope of his employment. He wasn't engaged as an employee when this alleged conduct occurred. Therefore, how can you hold him liable? So we'll see again how that shakes up. Now, as I mentioned, Tony Busby's law firm filed lawsuits on behalf of 6 new clients on Monday. He expects many more to be on the horizon, which is, not good news for one of the richest men in hip hop. Combs currently sits locked up in the Metropolitan Detention Center out in Brooklyn as he awaits trial on federal sex crimes charges, racketeering conspiracy, sex trafficking, transportation to engage in prostitution. And he is sitting there because he was denied bail twice. This is despite offering a bail package of $50 million, home confinement, a security team to monitor him, essentially 24/7, visitor logs provided to the court, no telephone or internet access, limited visitors coming to that property. Now, the problem for Sean Combs is that the courts were persuaded by the prosecution's argument. The gravity of Combs' allegations, the weight of the evidence, the potential danger he is to society, the risk of flight, and the allegations that he had been improperly contacting witnesses. Now, Combs appealed the latest decision to deny him bail. He appealed it to a higher court in New York. It's called the Second Circuit Court of Appeals. Now, in Combs' bail motion, and we've talked about this on a previous sidebar, so I'm going to get to this before I get into the new stuff, but they wrote, this case does involve extreme and unusual circumstances, but none that typically foreclose bail or warrant forcing Sean Combs to defend himself from a prison cell. What is extreme and unusual about this case is that Mr. Combs was detained immediately after he was charged. It goes on to say, the sensationalism surrounding his arrest has distorted the bail analysis. Mr. Combs was not released pending trial, even though he offered to comply with restrictive conditions that would have prevented any conceivable risk of flight or danger. Now, in this motion, Combs denies the government's accusations of obstruction. His attorneys concede that, yes, he spoke with people about the civil lawsuits that he was facing. Remember, he's been hit with a number of lawsuits, people claiming they were abused by him. But he says he wasn't aware that the Southern District of New York was investigating him. And he claims once he realized he was being investigated, the appeal motion says he made sure not to contact these people anymore. The motion reads, although the government vaguely described contacts with 2 grand jury witnesses, it proffered no evidence of any threats or intimidation. The government could only state that there were 14 total contacts between Mr. Combs and 1 witness and another witness who was contacted multiple times. Defense counsel explained these contacts involved no obstruction or witness tampering. For example, 1 witness contacted Mr. Combs, not the other way around. She reached out to Mr. Combs and told him, "I'm a grand jury witness." After Mr. Combs informed defense counsel, he was instructed not to contact the witness anymore and didn't. So in other words, Sean Combs' defense counsel is arguing that the prosecution didn't meet its burden to hold him until trial. Okay, so what's the latest? Well, the prosecution responded to this. They are opposing this defense motion. And at the very beginning of their filing, they lay out the status of the case, right? The arrest, the indictment, what has been happening with bail. But they also re-emphasize the allegations and the charges against Sean Combs. So to set the stage, they say, as alleged, Combs and other members and associates of the racketeering enterprise, wielded the power and prestige of Combs' reputation in the entertainment industry to commit federal crimes, including racketeering, sex trafficking, and other offenses, including crimes of violence. From at least 2009 through 2024, Combs used force, threats of force, and coercion to cause female victims to engage in sexual activity, which included sex acts with male commercial sex workers that Combs referred to as freak-offs. Freak-offs, which sometimes lasted days, were elaborate sex performances that Combs directed, say he pleasured himself during, and often electronically recorded. Combs ensured that female victims participated in freak-offs through coercion and violence, including by supplying female victims with controlled substances, subjecting female victims to physical, emotional, and verbal abuse, controlling female victims' careers, livelihoods, housing, and threatening to disseminate recordings of freak-offs. And after highlighting how serious these charges are, the prosecutors then focused on what happened at the other bail hearings in front of 2 other judges. Now, specifically, when talking about the second bail hearing in front of District Court Judge Andrew Carter, one of the main pieces of evidence to demonstrate that Combs is a danger to society and shouldn't be released is the 2016 videotape that was published by CNN earlier this year of Combs appearing to beat his ex-girlfriend Cassandra Ventura in a hotel hallway. And prosecutors say that even though Combs tried to say, hey, look, this had nothing to do with a freak-off, this was about a domestic spat, about infidelity, the government writes, based on multiple sources of evidence, the government proffered that immediately prior to Combs' assault of the victim, there was a male commercial sex worker in the hotel room with Combs and the victim, who remained inside the hotel room during the assault. Makes me think that that person is probably going to testify at an upcoming trial. Maybe that person was caught on surveillance footage. It goes on to say, the government then read text messages between Combs and the victim, which confirmed the victim's severe injuries. The government highlighted text messages sent by Combs himself immediately after the assault, suggesting that Combs feared a law enforcement response, including the following: call me, the cops are here, and yo, please call, I'm surrounded. The government emphasized that whatever the context, the undisputed conduct captured on video, punching, kicking, and dragging the victim, underscored Combs' dangerousness. And prosecutors double down on what happened in this 2016 video. They write, with respect to the March 2016 incident at the Intercontinental Hotel, Combs' counsel characterized the relationship between the victim and Combs as very loving, and freak-offs as a sought-after special part of the relationship. Judge Carter responded, what does this have to do with him punching her, throwing a vase at her, kicking her? What's love got to do with that? Combs' counsel continued to argue that there was no sex trafficking, but Judge Carter pressed him to respond to the argument that Combs' violent conduct was relevant to Combs' dangerousness more generally. Combs' counsel conceded, I think it's relevant. I haven't said it wasn't relevant. I'm saying it's not part of the sex trafficking. Combs' counsel nonetheless urged Judge Carter that even if the court doesn't fully trust the package as a whole. So in other words, I think a way of looking at this is, even if it didn't have to do with sex trafficking or racketeering, if you were trying to present the argument that Sean Combs is violent and a danger, whatever reason was behind him essentially beating Cassandra Ventura, that's enough evidence. That's it in and of itself. That proves the point. And prosecutors also explained how Judge Carter was especially troubled by the allegations that Combs was reaching out to witnesses, including witnesses who received grand jury subpoenas, that he was engaging in witness tampering, that he was engaging in obstruction. And they say Judge Carter properly denied Combs' motion for bail, just as Judge Tarnofsky did before him. Combs cannot demonstrate that Judge Carter clearly erred when he found, after considering lengthy written submissions, reviewing a transcript of the bail hearing before Judge Tarnofsky, and presiding over extended oral argument, that the government had established by clear and convincing evidence that Combs posed a danger to the community and that no bail conditions could reasonably assure the safety of the community. So let me take a quick second to explain this. The Second Circuit Court of Appeals, in order to overrule Judge Carter's denial of bail, they would have to find that he clearly made a mistake here. And the tricky part about that is, A, by law, this appeals court has to defer to Carter's reasoning when making this ruling. And B, essentially, they would have to find that the government hasn't established, by something we call clear and convincing evidence, that Combs was a danger to the community or that he would threaten or injure or intimidate a witness. The government has the burden. Yes, the government has the burden, true. But clear and convincing evidence, that is a low standard under the law. It is a lower bar for the government to cross than, let's say, beyond a reasonable doubt. Basically, the government has to show that there is a high probability of this. And here, given these specific charges, prosecutors say by law, there is a presumption that he should be detained. There is a presumption that the defendant is a danger and can't be out on bail. But they also explain that the defendant has a limited burden of production to rebut that presumption. But they also write, even where a defendant produces sufficient evidence to rebut the statutory presumption of detention, the presumption doesn't disappear. Instead, it becomes a factor to be weighed and considered like all the others in deciding whether to release the defendant. And that's going to be important in a minute. But first, federal prosecutors argue that Judge Carter's finding that Sean Combs is a danger, it was supported by clear and convincing evidence. They say Combs is ignoring the charges he faces and the strength of the evidence. They write, quote, as alleged, since at least 2008, Combs has engaged in serious acts of violence, including forcing and coercing women to participate in sex acts with commercial sex workers by using physical force, financial pressure, emotional abuse, narcotics. They continue, although Combs claims on appeal, as he did below, that the freak-offs involved adults voluntarily engaging in consensual sex, the grand jury found probable cause otherwise, and the district court properly credited the allegations in the indictment and the government's detailed evidentiary proffers. Moreover, undisputed video evidence corroborated that Combs used brutal violence against his victims, including by hitting, punching, kicking, and dragging them. And more specifically, when it came to that 2016 video, they write, even if the evidence did not support the conclusion that Combs' assault at the Intercontinental Hotel was related to sex trafficking, which it did, Combs' counsel conceded that Combs' violent conduct against women was nonetheless relevant to his dangerousness. Bottom line here, whether he struck Ventura because of sex trafficking or a domestic dispute, the argument is he's still violent, he's still dangerous. That's all that matters. Now, when it comes to obstruction, the government writes, in arguing that evidence of obstruction was thin and that the government provided no basis to believe that Combs tampered with witnesses, Combs primarily quibbles with the strength of the government's evidence that Combs made inappropriate contact with government witnesses, but Combs ignores altogether the serious and substantial allegations of obstruction, bribery, and witness tampering charged in the indictment as part of Combs' pattern of racketeering activity that amply supported Judge Carter's determination. So sort of using their allegations in the indictment to support the claim that he was reaching out to witnesses. Now, the government continues, the facts, including Combs' text messages that the cops are there, supported the inference that Combs wanted to destroy the hotel surveillance video to avoid prosecution for a vicious assault. And while Combs argues that witness contacts were minimally relevant or entirely innocuous because they concerned civil suits, the suits alleged years of physical and sexual abuse, including sex trafficking, allegations that Combs was plainly aware could subject him to criminal prosecution and investigation. Moreover, as the government made clear, Combs continued to contact witnesses, including witnesses who have received grand jury subpoenas into the summer of 2024, when he undoubtedly knew about the government's criminal investigation. Now, from there, the prosecution argues that Judge Carter didn't make a clear error or mistake when he rejected Combs' proposed bail package that I described earlier. Why? Well, they argue the government established that Combs used methodical and sophisticated means to silence and intimidate witnesses throughout the racketeering conspiracy and during the government's investigation. Combs often used loyal intermediaries to accomplish his objectives and wielded violence and blackmail, as well as his substantial wealth and influence relative to his victims and employees. To achieve compliance, Judge Carter therefore rightly concluded that the proposed conditions were inadequate because they would still permit Combs to obstruct justice and intimidate witnesses through employees and other individuals and even coded messages. Combs baldly asserts that there was not a shred of evidence that Combs used coded messages. As only one example, however, Combs tried to ensure a victim's silence about her sexual trauma by telling her that he needed her and that if she needed Combs too, she ain't got worry about nothing else, alluding to a promise of financial security in exchange for loyalty. Now, while Combs asserts that this incident did not involve an intermediary, Combs then texted an employee to ensure that his financial advisor kept paying the victim's rent. The evidence therefore supported the conclusion that even if confined to his home, Combs has the means and the influence to evade even seemingly restrictive bail conditions. Now, prosecutors, they also focus on a more policy reason too. Should we give Sean Combs, someone who is so wealthy and has the means to provide such an attractive bail package, the opportunity to stay out of detention because he can? A defendant who's facing such serious charges? They write, the district court rightly rejected Combs' effort to pay his way out of detention when the record established that no set of conditions can ensure the safety of the community. This court has expressly held that the Bail Reform Act does not permit a two-tiered bail system in which defendants of lesser means are detained pending trial, while wealthy defendants are released to self-funded private jails. That's an interesting argument there. And finally, prosecutors respond to the allegation that Judge Carter essentially summarily decided Combs was a danger and was engaging in obstruction without holding the government's feet to the fire, that they didn't properly prove he was doing the things that they were alleging to justify pretrial detention. In other words, government, where's your evidence? Well, the government responded, quote, given the thorough proceedings below, this court should swiftly reject Combs' argument that Judge Carter committed legal error by failing to make factual findings or to weigh required factors. While the Bail Reform Act includes a provision requiring written findings of fact and a written statement of the reasons for the detention, this court has explained that whereas here, the court's findings and reasons for issuing a detention order are clearly set out in the written transcript of the hearing, the requirement of a writing is satisfied. At the end of the hearing, Judge Carter denied bail only after reiterating, I've heard from the parties and I've reviewed everything, which included written submissions from the parties and the transcript of Judge Tarnofsky's bail hearing. As memorialized in the transcript, Judge Carter then specifically found that Combs posed a danger to the community and a risk of obstruction based on the evidence put before him. This is therefore not a case where the detention order contained only implicit findings or no finding whatsoever. So as the government in this filing is asking the Second Circuit to affirm Judge Carter's denial of bail, and for the reasons that I laid out, it seems quite likely they will do so because given the legal standard and given the evidence that has been presented, something else has happened which we need to talk about. Combs' team has now filed another motion asking the Second Circuit Court of Appeals to not do anything, to suspend his appeal of the bail decision. Don't do anything. Don't make a decision on it. It's called holding the appeal in abeyance. Hold it in abeyance until Combs' team has the opportunity to now argue the issue of bail in front of the new judge overseeing Combs' criminal case. This is the third judge in the case. This is Judge Arun Subramanian from the Southern District of New York. We talked about him on an earlier sidebar because he had a hearing last week. But this is really interesting. They're asking now the Second Circuit, don't do anything. I know you heard our arguments. I know you heard the prosecutions. Don't do anything yet. Wait until we have an opportunity to now present this issue to the judge overseeing the criminal case. Now, I know what you might be saying. I don't get it. Combs was denied bail twice by two different judges. He appealed this to a higher court in New York. Why is he asking them to wait on ruling on this? Why go to Judge Subramanian? Well, this is where it gets interesting. So Combs' team says that during that hearing that I mentioned with Judge Subramanian last week, and we covered it on a previous sidebar where they talked about the evidence, they talked about the trial date. Well, apparently the defense says that during that hearing, Subramanian remarked, if the defense has any bail application that they would like to raise, then the court will certainly hear it. Now in their motion, and this part is key, Combs' lawyers say because certain relevant new information has come to light since the detention order, Mr. Combs intends to file a renewed motion for pretrial release on conditions with an updated proposed bail package in the district court. Now, to be clear, not sure what they mean by new information. Is this something about Combs' conditions in the MDC? Could it be evidence that he did not engage in improperly reaching out to witnesses and victims? When they say new evidence, is it really new evidence, or is it something that they've already argued to the Court of Appeals? Not entirely clear. But they say this renewed request is based on, quote, changed circumstances. So that's really interesting. And what would a new package look like, a new bail package? Now, of course, if the district court approves bail for Sean Combs, his attorneys have indicated they will drop this appeal in the Southern Circuit. So we will wait to see what happens. There's a lot of moving parts. And of course, if Judge Subramanian has the opportunity to now review this bail motion, will he look at it differently than Judge Tarnofsky, than Judge Carter? Will Sean Combs be released? We'll see, with a little bit of unknowns about what the defense will present. But as we mentioned, the prosecution makes some very, very solid arguments. But for right now, that's all we have for you here on Sidebar. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. Speak to you next time.